evening, everyone, and welcome and thank you for coming to attend our family law update. We will be looking at financial update, public law update, and some private children law update. So I'm kicking off, and I'm going to be looking at the case of Standish and Standish. We had the final word in what I would call the matrimonial saga of the last 3 years in July of this year. And then Kane is going to come and talk to you about conduct and some practical insights from some recent cases. So, Standish and Standish, the journey to the Supreme Court. The case at first instance was known under a different name because both parties had been married before. The key issue in the first instance case was two events really, two financial transactions. The first was a transfer of some offshore funds, I think totaling some £77 million from Mr. Standish to his wife. The purpose of that was to take advantage of her being a non-domiciled in the UK, being from Australia. And he was due to be deemed to be domiciled back in the UK in 2017. So it was really a ploy, a scheme, a little ruse to avoid paying income tax and inheritance tax. The idea was that Mrs. Standish would put everything in a trust for the children and they'd avoid paying the nasty old taxman. Sadly, before that happened, they fell out. And they were finding themselves in the divorce court. Unbeknown to Mr. Standish, Mrs. Standish had also written him out of her will. The other event that took place was a transfer of some shares from the husband's company, also intended as a scheme to avoid tax. The pot was found to be 132 million. By the time it came to court at first instance, 95.7 million was held by Mrs. Standish, and these assets were accepted to have arisen premaritally on the endeavours of Mr. Standish. So, Mr. Justice Moore, when he worked his way through the parties' positions, he found that the only possibility, and I think that probably is where the successful appeal hung, was on his choice of words, that the only possibility is that the 2017 assets, so that's the offshore assets that had been transferred, had become matrimonial. And he gave us that wonderful phrase that the assets had been matrimonialised. He also found that the placing of the shares into the wife's name also matrimonialised these shares. So effectively, he was saying the change of ownership passed it from being non-matrimonial to matrimonial. But because he accepted that Mr. Standish had produced most of the assets, he departed from equality and Mr. Standish got a 40% share. Both parties appealed. Mr. Standish on the basis that the assets were never matrimonial and had not become matrimonialised. And wife's case was also, interestingly, that they were non-matrimonial now because they'd been transferred to her, and therefore husband shouldn't have had a share in them in any event. So this presented another opportunity to reaffirm the foundations on which the sharing principle has been built, and if it was necessary, to define further the definition of matrimonial and non-matrimonial property. As Justice Moylan observed, the sharing principle applies with force to matrimonial property, but not so to non-matrimonial property. So the issue is, how do you identify whether something has become matrimonialised or not? And on the appeal, there's two approaches, I'm not going to go through them both, but on appeal, Justice Moylan seems to have endorsed the latter approach, and he explicitly preserved the former, holding that the source of the assets, rather than the transfer of legal title, was a decisive factor in whether the assets had become matrimonialised. And he found, contrary to at first instance,
that the majority of these funds were non-matrimonial. And they reduced Mrs. Standish's award to 25 million, which is the largest reduction on a divorce on award in the Court of Appeal. The Court of Appeal really didn't add much in terms of the principles of understanding matrimonialised property, and it's the basis that the financial product of the party's common endeavour, which is arising from Miller, and or the fruits of the matrimonial partnership, as such, should be ordinarily equalised. In dismissing the wife's appeal, the Court of Appeal was critical to her case, saying that it ran counter to the principles in White and it undermined the attainment of a fair outcome. The wife appealed again, arguing that the Court of Appeal had placed excessive weight on husband's contribution and that the transfer constituted a gift. So she's changed her position from the first instance and indeed the initial appeal. I'm not going to go through them all, but the judgment in the Court of Appeal is quite useful because it sets out a really nice narrative of how we got to where we are in terms of what is matrimonial, what is non-matrimonial, and the sharing principle. But however, the Supreme Court's decision will no doubt now be our starting point. And so that was handed down on the 2nd of July of this year, and it confirmed that the sharing principle only applies to matrimonial property, not to non-matrimonial, and that equal division is the appropriate and principled starting point, but there can be departures from that where justified. Non-matrimonial property, I hasten to add, is still subject to need and compensation, although the Standish does clarify that any delving into non-matrimonial property is only so far as it's required to meet a party's need and not to be pulled into a sharing case. And quite interestingly, I had a case yesterday where the judge, when I referred him to Standish, took a rather unusual approach. I managed to persuade him on a very weak case that the non-matrimonial asset that had been pre-owned, pre-purchased by the wife had become matrimonialised, even though the husband had nothing to do with it, had never received any of the rental income and actually didn't know anything about it. But he'd lived there for a year before the parties got married, they cohabited, and so we said, well, that brings it into being matrimonialised. Oh, and it was his idea to rent the property. And that was the extent of our case. And Standish sets out here that if you're saying that something has become matrimonialised, the onus is on the party asserting that to show that it's become matrimonialised. And I think if we got to a final hearing, the decision would have been very different. So it's how the parties have been dealing with the asset and whether this shows that over time it has, or they have been treating as if it's shared between them. And it's the over time phrase that is used by Justice Wilson in K&L, means that the period of time must be significantly or sufficiently long enough for their treatment of that to treatment of the asset as being shared to be regarded as settled. And I'm sure that there is going to be some further cases as to what is sufficiently long. And it seems that we'll need definitions for just about everything. So in applying these principles, the Court of Appeal, the Supreme Court upheld the Court of Appeal's finding that 25% of the 2017 assets constituted matrimonial property and the rest fell outside of the sharing principles, and that the transfer to the wife was purely for tax inheritance mitigation scheme for the children and with no indication or no intention that they would become wives, and therefore they had not become matrimonial. And they unanimously dismissed her appeal, leaving her award at 25 million. And now I just set out in terms of the impact on high net worth cases. It really does suggest that prenups or even postnuptial arrangements and agreements may well be something that we should be advising our clients in respect of to protect those assets. And at the bottom there, it's created a new evidential challenge for the party seeking to prove that an asset brought into a marriage by one spouse has become matrimonialised. So those are the 5 key principles, fairly clear. They haven't really changed from the Court of Appeals principles that were set out, except for that little bit at the bottom that transfers between spouses made for tax planning purposes do not normally result in matrimonialisation, as the intention is usually to save tax. The other reason why I say this case matters is in respect of pension sharing orders. Now, while this wasn't necessarily a pensions case, it did give some guidance as to how the court should be approaching or could be approaching pension assets. So particularly those built up before marriage or kept wholly or separate throughout or originating outside. And pre-Standish, we'd often find a pragmatic and discretionary approach, especially in long marriages, even where pensions are pre-acquired, if the need of the parties for income or retirement required the whole of the pension to be utilised. This may no longer be the approach, and it's been made abundantly clear that there must be evidence of joint use, and this applies to pensions as well, for the benefit or intention to share to be caught by the sharing principle. So even in terms of pensions, there's a factual basis to say that the parties treated them as a matrimonial, or there needs to be rather. For example, someone who's drawn down from a pension, their tax-free lump sum, and they have put that into the former matrimonial house. Perhaps they paid for an extension, perhaps they paid off the mortgage, and whether that was full pension or part pension, matrimonialising their full pension pot. So in short, for pensions, in Standish, it means that only the marital portion is automatically up for grabs, and you've got to prove an interest in the rest. And I, again, have had a case recently where this principle has been applied, even in a needs case. The court identified it was a needs case, but applied the Standish principle and said that only the pension built up within the relationship was up for sharing. And that brings me on to the PAG 2 report. It's not a new report, it was January 2024, but that does set out expands in part 4 how treatment of pensions in needs cases and indeed in sharing cases should be treated. And it says that the date, I think probably the most important takeaway from that part of PAG 2 is that the date for the apportionment calculation is to commence at the date of seamless cohabitation. So not the marriage, but when the parties started living together. And there's a new section in that on short marriages, and they may need to evidence that they've got needs arise from the marriage in respect of generating an interest or justify sharing one of the non-matrimonial pensions. And I am now going to pass you over to Kane. Yes.
Right, thank you, Suzanne. My name is Kane Deach, as you heard. I'm a family barrister here at Guildford Chambers, and I am going to talk about everyone's favourite topic, which is conduct, specifically in financial remedy proceedings. Firstly, before I go into the case law, just by way of a show of hands, who's had a case recently where conduct has been raised and it's actually had an effect on the final outcome? I have to say, it's interesting, but I'm not surprised, and we'll actually touch on at the end of the presentation some of the areas potentially for reform moving forward, which could have an effect on this moving forward. So what I want to do in this presentation is I want to look at two aspects, which will all be familiar to all of you, but what I want to do is actually look at two cases which have touched on familiar aspects in dealing with conduct and financial remedy proceedings. And as the slides suggest, to take away some practical insights from those that could be applied in the cases that we all deal with. So firstly, looking at the first aspect, again, I'm probably teaching you all how to suck eggs. This is a very it'll be well known to all of you. The first aspect I want to look at is specifically what we all know, which is that reaching the required threshold for conduct to have an effect in proceedings is a high one. We're all familiar with the statutory wording, it being equitable for the court to disregard, and we have some of the gloss that's added to the statutory wording from the case law. You'll all be familiar to the obvious and gross test, sometimes referred to as needing a gasp factor. I.e., the judge should pick up the case papers and have it should draw a gasp basically from what they read. And then thirdly, what's referred to as the exceptionality requirement, which is that in certain cases, it's only in exceptional circumstances that the conduct of a party can be taken into account. So again, I'm teaching you how to suck eggs. This is a very obvious and well-known point to all of us. And as I say, later we'll look at some cases actually to see how this is applied on the ground. And the second aspect, again, this is very much the fodder of recent seminars. It's in respect of specifically the case of Svetkov and K. Rover, and it's looking at the correct procedure about if you feel that conduct is potentially a runner in a case that you're dealing with, how you actually go about that and how you get the court to consider this. And again, very familiar to all of you. It's well worth reading that report in its entirety. It's very helpful and instructive. But teasing out some of the key points, it's very important if you are pursuing conduct that you nail your colours to the mast at the first appointment, particularly if you filled out the relevant box in for me. Second point, again, you need to particularise allegations that you're making, and that's usually through seeking permission at first appointment for a witness statement to be filed. And then thirdly, it's said in K. Rover that there needs to be a link, a financial link to the conduct that's complained of, although, as I've flagged in the slide, some of the recent authorities actually, that principle hasn't been applied in some of the recent authorities, so you can query whether that is still, well, it's certainly not settled law, and you can certainly query whether that's going to be held moving forward. So far I've talked about two aspects which are well known. What I want to do is actually look at two specific cases to see in practice how these have been applied, because it's all well and good for there to be a recital about what the principles are. But of course, when we bring it into our own cases and we try and predict how the court is going to interpret this, it can be helpful to look at first instance how that's been done. Now, the first case I want to look at on this first aspect, which is considering a threshold that needs to be met. The specific case, the name and citations on the slide there, it's the case of MRU against ECR. It's one of those anonymised case names, which are always very difficult to remember. And the neutral citation is there. It's a decision by a Deputy District Judge by the name of Benjamin Rose. And as I flagged on the slide, because this is a first instance decision by either a district judge or a circuit judge, it's not one that you can formally cite as authority, but as I said previously, looking at how the DDJ applied these principles, I think can be helpful, because it's useful to see, as I said, first instance, how this is applied. But as I say, it's not something that can be formally cited as authority. What are the facts of this case? Well, as you can see from the slide, it's certainly on the severe end, in the sense that one of the parties in the case had actually received several criminal convictions for domestic abuse offences. It was in this case that the wife had pleaded guilty to threatened and actual violence. And she'd actually received a 4-year prison sentence for it as well. So it's very on the severe end of domestic abuse in the context of many of the cases we deal with. Children and family, they all lived with the husband in this case, and it was in direct contact only with the wife. And again, as I flag at the end, it was very much a needs case, because I think, from memory, the only assets really in the case were some modest pensions and the proceeds from the sale of the family home. So again, I think it's useful to look at this case, because how many times do we deal with cases at first instance where there's simply not enough to go around to meet both parties' housing needs? And so it can be helpful to look at how conduct is interpreted at first instance in that context. So those are the facts. Now, the outcome of the case was that all of the proceeds of the family home went to the husband, who was the primary carer for the children. But there are a few, I think, practical takeaways from the case which can be helpful when considering your own clients and cases, which is that first, in this does sound a bit self-evident, but given how highly the threshold for conduct is stated, it can be helpful, I think, for a reminder that in this case, that the convictions that the wife had received for very serious domestic abuse offences, you'll see if you read the judgment, the judge didn't need to hear or didn't address it much at all, in the sense that he was content that the threshold for conduct was met off of that alone. And interestingly, in this case, the DDJ didn't touch on there being a financial link at all. He was satisfied because of the severity of what the wife had been convicted for, that the threshold for conduct was met. Second takeaway from the case was that the wife at final hearing was seeking to suggest that because she'd received a conviction for these serious offences, and because that had affected her earning capacity, that should have been something that the judge should take account of. I can tell you now, if you haven't read the case, or the takeaway from the case is the DDJ rejected that very quickly. That argument that did not go down well at all, I think it's safe to say. But this is relevant in a needs sense, because the wife in the case was running an argument in respect of her income needs, and the fact that her earnings had reduced because of the conviction, as I say, didn't find any safe harbour with the judge. Thirdly, and again, I think this is a practical takeaway, of course, we're all aware of the distinction between soft and hard loans in financial remedy proceedings, and how judges can compute those and how those are met potentially from the proceeds. Again, the wife in this case sought to suggest that the debts that she had incurred with her criminal defence solicitors, they were hard commercial debts, certainly something that needed to be repaid. She sought to suggest that that should be taken account of in the judge's decision. And again, I can tell you now, the DDJ did not find favour with that argument, because the costs that she'd incurred from her criminal defence solicitors were associated with the conduct that she'd done. So I thought those takeaways could be helpful, because, as I say, it can in some cases be difficult to gauge how a judge is going to react to certain conduct arguments, and some judges might insist on there being a financial link in line with K. Rover. But looking at this case, again, it can't be cited as authority, but certainly if conduct complained of is severe enough, as it was undoubtedly in this case, a 4-year sentence in prison being served because of domestic abuse offences, then certainly that's something that can meet the threshold. And then there's some other aspects in relation to responding to arguments in respect of how to deal with certain debts and earning capacity issues. So that's the first case in respect of the first aspect of conduct, which is meeting the threshold. The second case I want to look at, which is in relation to the second aspect I talked about, which is about how you go about pursuing conduct, if that's what you want to do, is the case of Y and Z. It's a decision of Mr. Justice Cusworth, and the neutral citations on the slide here. Facts of the case, again, it's not essential to know the facts of the case, it's more the principles that are derived from them, but by way of a brief background, it was a prenup case. It was a prenup case where the validity of the prenup wasn't disputed by the party. Both parties accepted that it was valid and binding. The parties agreed actually how much was due to the husband under the prenup. The quirk in the case was the fact that the wife was alleging that the husband had in fact already received the majority of what he was due under the prenup. And the reason for that was because the wife was alleging that essentially that the husband had, stolen the sums that he was due from not only joint accounts that the parties had, but also her own sole assets. So that's this by way of a brief background. Practically speaking, though, what was interesting about this case in terms of takeaways for our own cases was that it was, notwithstanding all of these allegations that the wife had made both before and during the proceedings, it was actually agreed at the first appointment and recorded on the first appointment order that conduct wasn't going to be pursued in the proceedings. We can only guess as to why that was. I imagine that might have been with a view to the threshold that needs to be met for conduct. Now, as you could probably imagine, the wife had second thoughts on that moving forward and sought to resurrect her conduct argument beyond the first appointment, despite it being recorded in the first appointment that it wasn't going to be pursued. And what I thought was interesting about the case of Y and Z was that Mr. Justice Cusworth, notwithstanding the fact that conduct had been barred by agreement in the proceedings, the judge actually allowed it to be reopened as an issue, notwithstanding that agreement. And I thought in terms of applying it to our own cases, what the judge's reasoning for that, the reason why he allowed that to be resurrected, was because it was an issue, the conduct allegations had been raised throughout, both before and after proceedings. It was something that the husband was very well aware of was being alleged against him. And therefore it wasn't a surprise to him. So again, if you deal with cases where potentially conduct might have been barred by agreement moving forward and you want to revisit that issue, of course, if there's litigation conduct after the first appointment, that's something that can be raised anyway. But if there is want to reconsider conduct, then this is a good authority to hang your hat on. But there were a few other, I thought, helpful takeaways from this case of Y and Z. Again, some of these will be well known. The second takeaway was that even if conduct is barred in the proceedings or it hasn't been pursued, that doesn't stop you criticising the circumstances which a prenup came about, of course. And this was a point of principle raised by Mr. Justice Cosworth. So if there's any concerns that you or your clients have about the circumstances which a prenup came to be, that doesn't have to be encompassed within the conduct argument. That's something that can be raised separately. Another takeaway, again, this is perhaps stating the obvious, which is that the conduct of a party, their misbehaviour, even if that's not pursued under conduct formally, that's still something that, of course, can be considered within their assessment of their earning capacity and their resources moving forward. So again, it doesn't have to be necessarily captured under conduct. And then the fourth and last one, again, is that there's different ways to cut the cake in relation to someone's misbehaviour, in the sense that it can still be taken into account when the court looks at their housing needs or their income needs. If you're considering, or another party is pushing for perhaps a maintenance order, even if conduct hasn't been pursued in proceedings or it's been barred, that's still something that the court should take account of when it's assessing the level of maintenance that someone requires. So those are the two cases I thought were helpful, looking at the two aspects which are well known to all of us. I flagged at the beginning in relation to conduct. Again, this is a hot topic for seminars recently and discussions recently. The Law Commission, back in December 2024, they released their scoping report about potential areas of reform in the area of financial remedies. So I have to say, it's a very full-on report. I think it's nearing 300 pages, so I think some bedtime reading. But I would strongly suggest on the issue of conduct, they've got a great, I suggest reading the full section, but they've got a great précis which talks about the areas of potential reform for conduct in financial remedy proceedings. And one of those is essentially reassessing the requirement for a financial link between conduct that's complained of, basically. And it's interesting, as I say, that DDJ in the first case we looked at didn't require that as something in the case. So highly recommend reading the Law Commission's scoping report if you haven't already. But that's my presentation in respect to conduct.